I'm joined now by Ashraf Essop, who's an immigration and refugee law expert. A very good afternoon to you, Ashraf. Thanks very much for your time. I don't know what you make of these events.
Good afternoon. Thanks for the opportunity. Look, I think we need to start with the following premise. This is not the first identity problem the department is facing. In fact, they are on record as having blocked 1.8 million identity documents. This matter then went to court, and the court said in the matter of PPM versus the Minister of Home Affairs, I get it, you need to block IDs, but you need to do it in the correct manner. Now, what is the correct manner that one deals with this? Here, you've been told it's a prima facie case. The correct manner now would be to invite all the interested parties to a meeting with the department before they make such a decision. And if they incline to make a decision to deprive anyone of their citizenship, they have to do so in writing. But they have to observe due process. Due process is in respect of both procedural fairness and substantive fairness. These are rights guaranteed in the Constitution. The right to an administrative decision that is lawful, reasonable, and procedurally fair. So in terms of lawfulness, if you are going to be deprived of your citizenship, well, then only the minister, in terms of the Citizenship Act, has that right. And only the minister may remove that right to you. So you can see there's lots of checks and balances built into the various pieces of legislation that govern this kind of thing. Primarily, I've identified the Constitution, which protects everyone within its borders, and particularly in terms of the Bill of Rights, there are certain rights to the citizenship that you're entitled to, such as a passport, such as the right to leave and enter the Republic. These are exclusively reserved rights for citizens. Now we come to the Promotion of Administrative Justice Act, and that requires that any decision taken by any official that materially and adversely affects your rights must be done in writing. And Part 3 or Section 3 of the same Act says there has to be procedural fairness, which I've already outlined. They have to give you a statement in writing. They've got to tell you you're entitled to come and challenge the information. You can bring your own information. Maybe there were mistakes made. We don't know. We don't know what the applicants have in their possession that may swing the matter back into in their favor. There could have been an administrative bungling. Yes.
But who are these people who must be consulted first?
The applicants, the ones that are now being told that there's a prima facie case against you, both mother and child, because the child has received its birthright through the mother, and the mother's documents may be now in question. And obviously the child received citizenship based on the strength of the mother's citizenship. So both are affected parties, and the department is definitely going to affect or send a notice to both the parties saying, we intend to deprive you. Can you come and give us your side?
But then, I mean, there are, from what we often get told, scores of people who are here illegally or who may have stolen other people's identity. So unless and until there's that prima facie evidence or they get caught, they will never come forward. And my understanding is that this is the first of many steps that have to be taken. Right now, they would have been notified that there's a prima facie evidence suggesting you've done some wrong. Come and state your case, isn't it?
Yeah, that's the correct approach. It doesn't matter how many people are faced with the same kind of challenge. That's why I said in the opening statement, there's 1.8 million people already, which is like 5% of the South African population, that are already facing blocked IDs for one or other reason. But the courts are saying, we understand that you can block it. That is true. But follow the procedure. Follow PAJA. Give them an opportunity engage with them, let them come with a legal representative, let them know their rights, let them be aware of the power of review. In fact, even if the minister makes such a decision, there's an overriding application that you can make to court to review such a decision. It could be based on error of law, it could be based on mistake of fact, it could be based on them taking irrelevant considerations into account, it could be unreasonable. You know, there's a whole host of substantive procedures that one must observe in terms of the Administrative Justice Act. So it's not like the days of apartheid, you know, a mere flick of a pen could deprive you of your citizenship. That's why the Constitution is so particularly empowered to protect citizenship.
From what we've seen and heard so far, is there anything to suggest that no proper procedures were followed?
No, I think the procedures are unfolding. You've just heard them saying, we've done site visits, we've done hospital visits, we have prima facie evidence, we're interviewing officials, and we're seeking legal advice. That, I submit, is the correct way. There is no deprivation. This woman is a citizen as we speak. Nobody's removed that yet. They intend to do so. And this is the correct way the Home Affairs is dealing with it.
Ashraf Essop, let me thank you for your time. Really appreciate it. He's an immigration and refugee law expert.